this is your briefing for the for your I think probably half the room are going to be in the grand jury by the look of it. So there's a 50% chance you'll need to know what I'm just about to tell you. Grand juries, what next? I'm assuming that at least one out of the 4 grand juries we're going to convene is going to recommend a prosecution. What I've done is research different strategies for dealing with those prosecutions. Michael Doherty this morning taught me all I know about private prosecutions. I've got a couple running about firearms matters. The other side don't like them. When I say the other side, police forces don't like them. First, they try and fob you off. Invariably, when I write asking for them to supply me with evidence, they say, "What's a private prosecutor?" And I have to refer them to a judgment from the Supreme Court in 2013 called Gurja, where it was tested. I noticed some of you writing it down. Gurga, Supreme Court 2013. And what happened was there were two there happened to be family innovations, and they're always having arguments in. I think it was Brighton, and each side reported matters to the police, and the police did nothing. So one side decided to go to the magistrates' court and start a private prosecution, and the district judge, sent the chap away and said, "No, you've got to report it to police first," and it's not true, and it ended up in the Supreme Court. A judgment in the Supreme Court is a handy thing for the layman to read because it's narrative. The legal argument is laid out nicely by the judges. They're all public school educated, aren't they? And they're good at English. And there are 5 judgments, and basically they're history lessons. One of the things about studying the law is the older a provision is, the more likely you have to look at a history book rather than a law book to find out what was going on. And that's what these judges have gone because the right to private prosecution goes back a long way. Commencing proceedings. You remember I said we're going to talk about the options. Well, the first is going. I'll go to court clutching the presentment, and it'll be the Old Bailey, and they'll try and fob me off and send me to a magistrate's court. But and we'll see what happens. And the first thing that should happen is that the clerk of the court or the magistrates or the district judge, when they hear the evidence, should say, "Fine, that's good enough. We'll go ahead." I've got a document which is published by the Law Commission. Again, if you're studying law, the Law Commission look at issues from time to time. And although I don't approve of them, because I think it's Parliament's role to study the law and suggest improvements, they are very good because they're learned lawyers and they're quite prepared to lay out the arguments. So if you're researching a topic that's new to you, I suggest you go to look at the Law Commission and see if they covered it, because it's an easy way for a layman to find out what the score is on a particular topic. So what we've got is a Law Commission document here. I'll quickly summarise it. A prosecution may be commenced by the accused being charged at the police station, it says at the top rather, and the magistrate may either issue a summons requiring the person named to attend court and answer the information, or issue a warrant for the arrest. That's fine. The information may be laid by a prosecutor in person, a legal representative, or some other authorised person. In deciding to issue a summons, the magistrate is performing a judicial rather than administrative function. They shouldn't fob you off. And their decision can be queried by judicial review. So hopefully they won't fob me off on the first occasion. Authority to refuse if the application appears to be frivolous, vexatious or an abusive process. Well, I'm at risk of being declared vexatious, aren't I? But there we are. The proceedings may commence by way of a charge at the police station, which is what I used to do for a living. Or at the bottom sentence it says, and those instituted by private individuals not acting in any official capacity. Well, actually, I think I am now if I'm going to represent a grand jury, aren't I? Now, this is one of the issues that scares the other side. I don't think Michael's put enough emphasis on this, so perhaps it's my fault, but this is what the Law Commission says. Once a case has been committed for trial, a private prosecutor can compel the police, through an application for witnesses summonses under the Criminal Procedure Attendance Witnesses Act, produce all statements and exhibits. Is Mike in the room? No, he's not here. To produce all statements and exhibits relevant to the case that they have in their possession. That's quite a scary thing, isn't it? Yeah? It means Crown Court. Yeah. So once we get the summons issued by a magistrate's court for committal to the Crown Court, then this kicks in. In actual fact, there's an additional provision which is called disclosure. And I'll just quickly cover disclosure. There's two sorts of evidence. There's evidence which incriminates somebody, and there's evidence which exculpates, gets them off. And they're equally important. And policemen who only go down the incriminatory evidence route and ignore the exculpatory get in big trouble because they're perverting the course of justice. And they were warned in 2005 by the Attorney General, if you try that sort of thing, then you'll go to prison for 5 years. I don't know if it actually happened, but it's certainly a risk. And at the time, it was quite dramatic. Everybody was told about it and sort of strictly warned because there'd been some sort of dreadful case where the police had hidden evidence. It's happening again, isn't it? Yeah. So once we get an indictment, then this provision kicks in, and the police can be compelled to hand over all their statements. So let's say you have a serial abuse that we're talking about, and there's multiple victims. I would argue that the prosecutor is entitled to know about the allegations from those victims if they concern the same suspects. And the ball starts rolling then, doesn't it? I'm quite looking forward to that. What happens if magistrates refuse to issue summons? Judicial review, with emphasis on the fact that the Crown is required by common law to accept a presentment as grounds for placing the matter before a petit jury. Okay? Because I made the argument yesterday that when the grand jury makes a decision, it's telling the Crown to have a trial, it's not asking. So there'll be legal arguments about the stuff I put over yesterday. So I think that's quite a likely outcome. Now there's a third route which is not widely known. I only discovered it a month ago, to my shame. But there's a gentleman called the Attorney General. Who's heard of the Attorney General? Yeah, they are a political appointment. They're a senior lawyer usually. Although law officers are particularly politically active as members of the legislature and as members of the government, in their capacity as legal advisors or when discharging their duties as participants in legal proceedings, they're required to act impartially. Okay, so he may be a political appointee, but he's got a duty to act impartially. The Attorney General is the guardian of the public interest. This function is demonstrated by the role of the Attorney General, both in relation to criminal and civil proceedings. Sounds good, doesn't it? So how, in practice, do you get the Attorney General to guard the public interest? Well, in criminal proceedings, in addition to powers that grant or refuse consent to certain prosecutions, the main function of the Attorney General in regard to criminal proceedings include instituting and conducting prosecutions of exceptional gravity or complexity. So I would say our cases are exceptional gravity, aren't they? So really he or she should take it over, shouldn't they? That's one of the options. He or she should take it over. And with the best will in the world, I'm only one person, aren't I? If you good people return to your home counties and start generating other cases, you're going to create a workload for this gentleman, aren't you? And that's when it becomes political, doesn't it? It's the weight of numbers, isn't it? So your mission is to go out and generate other grand juries and put some pressure on this bloke. You'll be able to see the reference at the bottom when you look at the video in slow time. Now here's a technique. Civil relator actions, I think that's how you pronounce it. The relator action is a device by which the Crown's procedural privilege is being made available to private plaintiffs. So if they're going to call us a private plaintiffs, they're saying that grand juries don't apply. We're still private plaintiffs, aren't we? So it's heads we win, tails they lose. A private individual will have standing to restrain a breach of the public law where the influence of the public right involves some interference with private rights, or perhaps where the individual is threatened with special damage over and above. That's damages cases. In other cases, the Attorney General can institute proceedings to vindicate public rights. So you can go to the Attorney General and say, my public right. And the public right we're talking about is the rule of law, isn't it? The rule of law is the concept that whoever you are, the law is above you. And these people are suspending the law, aren't they? Every time an allegation disappears into a black hole in a police station or a social service department, they're suspending the law, and that's what we seek to uphold. The Attorney General can act independently, but in practice he or she usually acts as the relation, that's where the relative term comes from, of a private individual. A court can always hear cases brought to the instance of the Attorney General, because the Crown will always have standing for this purpose, whereas a private plaintiff might be refused relief on the grounds that he or she is no more interested in the matter than any other member of the public. Now, a lot of people that have got involved in legal stuff have been refused action by courts because they're told they haven't got standing. Heard the term standing? Someone's probably come across it, haven't you? Where the court finds some excuse to fob you off. Well, this answers it. Yeah? If it's a public right, well, you will have standing, and I've got the Attorney General standing behind me. A relator action may be brought against public authority that's acting or threatening to act ultra vires. Equally, it may be brought against a private individual or anybody committing a public nuisance or otherwise violating public law. Public nuisance is a common law crime of failing to comply with a common law statutory obligation. So, for example, if your social services department is not looking after children, you're not complying with your obligation, are you? So that's one of the things we're talking about. So in order to research this, I write to the Attorney General's office, 19th of February, and by return of email, I got a document. Now, it's a bit small, but basically it says, write to us, tell us what the issue is. It did say that you have to get an opinion of a barrister, you have to get certified to the barrister you've got a viable case. And I've challenged that because that puts a legal obstruction in the way of access to justice, doesn't it? Yeah. In actual fact, there's a precedent in that. It's called the Whitturn case. It's about 15 years ago. And a man had no money but wanted to sue somebody. There was a fee for the suing before he could go to court. So it ended up in the House of Lords, and the House of Lords said the fee system has also got to have exemptions for people who've got no money. So that's probably the route we're going to go down. I'll show the second slide and the third slide. Salon's photographing it. Yeah, there we go. And that's the route we're going to go down. And the third one is compensation. Compensation. Let's imagine children in the care of social services. Payments in case of maladministration, where a relevant authority can consider that action taken by and behalf of an authority in the exercise of their functions amounts to or make to maladministration, and the person has been or may have been adversely affected by that action, the authority may, if it thinks appropriate, make a payment to or provide some other benefit. Now, you're all thinking may, aren't you? May means must in the interpretation of statute when it's necessary to effectuate a right. So if they've all treated you, they must. So that's quite a handy thing, and I suspect that's what they're scared of. The fallout from Rochdale and that sort of thing is going to cost them big bucks. So what I'll do is I'll circulate more information about that and we see if we can encourage some people to make claims. Kaz being the number one starter, I would think. Yeah. Yes, yeah, there we are. Just need to know what maladministration is, and the common law of England, all misconduct in high places, all oppressive and over-member acts on the part of those dressed with a little brief authority. I used to have a brief authority as a policeman, didn't I? It's all gone now. And that's the way to look at them. That puts them in perspective, doesn't it? Petty officials with a little authority for a short time. Corruption, fraud, accepting bribes, extortion by public government, and so on. So that's what we're going for. Okay? So any questions? Right, what's going to happen next is we're going to have a break, as I understand it. Is that right? You'll be divided into grand juries, selected at random from the corners of the room. We've nominated ushers who are going to do that for you. So when you return, could you come to your table, and the ushers will direct you from there. Okay, and as I say, it looks like probably 50% of the room will be in the jury. That's the best we can do. We've got 4 different cases for you to consider. Okay, any questions? Gentleman there.
Is there anything that bars you from sitting on a grand jury?
Well, you've got to be a British subject, and we've debated and discussed the issue of whether you have to be a householder. And since we're not going down the treason route, we're going down the misconduct route, we think that you've just got to be a solid citizen. Is it recent? I shouldn't say that. Tactless. It's between you and your conscience. Between you and your conscience. It's between you and your conscience. Juries members of juries can be excluded, but the test is: are you now an honest citizen? I would say it's between you and your conscience. We don't want to give the other side the opportunity to discuss, but there will be secrecy within the jury. So it's between you and your conscience. Yeah, they can, yes. Yeah, there's a facility to challenge jurors. It used to be exercised in the Crown Court. A person who was on trial could challenge jurors. So what we're going to say to you is, if you feel you shouldn't be on a grand jury, don't put your hand up. Yeah, okay. So you've got to be a British subject of good character, shall we say, a solid citizen. Good question. Well spotted. Anybody else? No, I can't see anybody. Right, time for a break. When should we come back? 4 o'clock. Okay.
Come up to me, petrified, asking whether this was obligatory. No, we're not forcing you to be grand jurors. You willingly put yourself forward to be one, okay? So you don't have to do it, but I'm assuming half of the room will, just because of the strength of the case. Oh, we have a question? Oh, sorry. So, yes, I think we're going to have a lot of volunteers, but as I said, it's not obligatory. We're not forcing you to do anything. And, yes, over to John.
I think it's a tradition to say, oh yay, town crier style. Can I have your attention, please? Serious business. Hasn't been done for 70, 80 odd years. Think of all our ancestors looking down saying, sort it out. Okay. The ushers are going to move to the corners of the room. Okay, if you do that, choose a corner of the room each. If you feel qualified to be in a grand jury, British subject of good character, and it doesn't mean you have, even if you have got convictions, it doesn't mean you have bad character. Once the ushers are in the corner of the room, could you put your hand up if you wish to stand? Okay. Yeah. Question. No, you can affirm. You can affirm. Yeah. Okay. Right. Okay. Ushers, could you select a jury between 12 and 23, please? From the whole body of the room. Don't just do the corners. Take some from the middle. Sorry? I expect 5 o'clock. Yeah, less than an hour. Yeah, I think so. Yeah, it's a straightforward one. Yeah. Gentleman's just asked me how long that we expect this to continue. I would think not later than 5 o'clock. Right, could I ask the persons who haven't volunteered their services to move to the centre of the room? You have to change seats to leave a table for each jury in the corners. So that if you're not on the jury, could you move to the centre of the room, please? Is anyone short of volunteers? The far right-hand side seems to be a bit thin. Yeah, if you wouldn't mind moving in, because those two tables can be a jury, can't they? Right, ushers, signal when you're ready, please. Good suggestion from the team on the right. Just move the chairs, not the tables. So if you put the chairs in the circle, that's probably the answer, isn't it? Yeah, two more jurors. Any more bids for it to be a juror? Okay, we're 3 short. We're 5 short. We need 5 more volunteers, please. Unless we reallocate, this one seems oversubscribed. Yeah, you can ask for 3. Yes, feel free. Right, ushers, could you report? I'll get my microphone. Ushers, could you report in, please? How are we doing? 12. Okay. Any extras? We need another 4 on this corner. How many have you got over there, please? 13. Can we spare 1? So how many were we short? 3 short. 3 more volunteers required, please. Well, not required. Requested, please. Is there anybody outside? Remember the privacy requirement. Okay. This will be filmed. You can see it later. Don't point at the juries. How are we doing? Still 3 short. That's your last opportunity, because otherwise we're going to have 3 juries, not 4. There's 1. Okay. 2 more, please. Don't be shy. It's your civic duty. One more jury requirement. Justin, are you volunteering? Okay. Ushers report in. How are we doing? Front. Okay, the front seems to have a quorum, doesn't it? How are we doing? How are we doing on this one, Alex? Are we up to strength? Okay. Ushers, can you move on to the next stage, which is handing out the statements and a copy of the juror's oath? They've got them. Okay. Right, the ushers will now invite you to declare or affirm the juror's oath, which is on the first page of your bundle. Ushers, if you're ready, just swear them in. They can all read it out at the same time, but the name changes, obviously. Okay, yes. It is a solemn occasion. Can you just be quiet for a moment? You don't have to be religious. It's solemn anyway. Right, jurors, take the oath, please. Well done. Right, the grand jury is in session now. Now, you've each got a statement concerning the subject matter that you've been assigned randomly. Can you read it, please? And you have to make a decision whether you want the live witness, the person who made the statement, to speak to you. A point that's come up from the front left-hand jury, they don't understand one of the words in the statement, and of course that's a good reason for calling the witness, so you can have live evidence from him or her. Right, for the benefit of the organisation, can the ushers indicate whether they decided whether they want the live witnesses? Take that as a yes, Nick? Yep. Okay, yes, okay. Who's your witness? Mike Doherty, okay. Call Mike Doherty. Michael Doherty, could you come to the front, please? Thank you, yep. Michael, shortly the jury's going to go out, but if you accompany them, they've asked for your evidence in person. How are we doing? Call Edward Beck, please. Edward, can you come forward? Jury's at the back. Can you indicate whether you want your live witness? Okay. Can you listen in, please, particularly people who are unallocated? We need one more juror. One more juror's got an issue and has had to leave. Can we have one more juror, please? Or have we got... We're asking for a volunteer. One more juror volunteer, please. Kaz, can we call Kaz? Can you come to the front, please? Right, I understand that the jurors have finished their deliberations. Is that correct? Can I have a confirmation from the front right? Perhaps not. Yep, I'll just get the... How are they doing? Alex? Okay. Right, ushers, could you just give an indication of how you're getting on? Somebody's calling, yes? A question? You're ready for the questions? Okay. Right, let's make a decision. Can you take your jury out and go to the left-hand side of the room outside, please? Yep. Ushers, I'm going to leave it to your responsibility now. When you're content that you're ready to hear live evidence, can you go outside to the other room so that we can leave the audience in the middle for the next stage of their presentation? So ushers, can you consider taking your juries out now, please?
Doom Watch is going to start promptly at 8 p.m. It's going to be a cracker. The theme is going to be the grand jury. So we want the questions related to the grand jury. And John, Alex and I have a question. Will the jurors be able to discuss the case on Doom Watch?
No.
Okay.
No. The short answer is no. We're taking this seriously, so no. One exception, I say unfortunately, Guy's jury were unable to achieve a majority, and that can be discussed because it's not a judgment. Alex Thompson was the foreman in that case, and he's going to give an account, I think, of what happened. I think that Guy is taking it like a man. And it proves the concept, doesn't it? We appear to be fair. Well, I'm glad to say that the other three presentments were accepted. Edward, thank you. Edward Beck's issue on whether the possession of firearms is a right or a privilege was the first one by 12-0. Michael Doherty's 13-0. There's a case to answer against a senior official somewhere in the food chain that blocks his case. She will have to justify her actions. Can't say too much about that. And then I'm glad to say, Kaz, where are you, Kaz? Is Kaz still here? Kaz has gone out. Kaz was able to put her case over, despite the difficulties that she's had through life. And I'm glad to say a jury of appears by 12 votes to 0 decided there's a case to answer against a detective constable that didn't allow her to present her case by saying that you've got to be alone in a room with me. So I'm glad to say that we've got that one. Now, I have prepared a presentation called Starve the Beast about council tax, which may be interesting to some people here. Due to the time constraints, what I'm going to do is ask the cameraman to film it at some point during this evening, and as soon as possible, I'll go on the BCG website with the slides. And what it's doing is enlightening those that don't know that there was lawful grounds for not paying council tax, for withholding it. And if you wish to go down that route, how to do it. There's many different strategies applied, haven't there, so on. This is my personal one because I'm mainstream and I use the Acts of Parliament. Other people use the common law. Okay, so round of applause for us all. Thank you.
Kay found a hotel key card in the sofa. You got yours, Michael? Is it? Okay, brilliant. I don't know what to say. Have a nice dinner.